Hello, and welcome to the IMS Insights podcast. Today's host is Cindy Buxton from the IMS Z-Access European team. Joining her is Clea Bigelow-Nuttall, a partner in Pinsent Masons London office, who specializes in commercial and investment arbitration, including the mining and energy sector. Cindy and Clea will share insights from their recent work on a mining dispute and explain why it's so important to tell a visual story to the tribunal. If you're listening only and would like to watch the interview, please visit our YouTube channel.
Clea, thank you for joining us today. Before we get into the specifics of a case that we worked on together, I wanted to ask you, what role does a visual presentation play in your overall strategy and storytelling in an arbitration?
Well, thank you very much, Cindy. It's an absolute pleasure to be chatting with you today. Visuals and storytelling. Lawyers are storytellers. Our job is to leave a tribunal with a compelling, a clear, and accurate understanding of our client's position. And in my experience, visuals are one of the most effective ways to be impactful. So in arbitrations, there are lengthy written submissions, long hearings, long oral openings, and a visual is often one of the best ways to make an impact and to underscore a key point that you're trying to get across. If you can distill your case down to a few key points that you want a tribunal to understand, to have in the forefront of their minds when they're deliberating, then often an image, a visual, a tool that you can leave them with either during that hearing or afterwards, to my mind is really effective in telling that story.
And when do you typically start thinking about visuals for any of your cases? How soon do you get involved yourself?
Well, I think ideally as early as possible. As I mentioned, there are often written phases of an arbitration before you get to the oral hearing, but the case preparation itself happens, often long before that first written submission goes in. And I think that the earlier that you think about how to communicate the key messages and whether that's done using visuals, I think the better. A lot of the work that I do is in the construction and infrastructure sector, and those are projects, those are disputes that are about tangible things that often an image is really engaging or useful. Often our disputes will involve lots of things like plans, diagrams, site photographs, and all of that kind of goes onto the record at some point in the arbitration. But the earlier you can start identifying which of those images are going to help you get across some key points and how you can use those to create some visuals, I think the better. That said, I also know that sometimes it's hard to engage our clients to get them on board with visuals early, because for them, first of all, they don't want to be in an arbitration, and second of all, if they are in an arbitration, they may not want to see it running its full course through to a hearing. And so often, if you are talking about visuals as something that's used at a hearing, that's not necessarily the narrative that a client wants to hear. So sometimes when we're talking about visuals, we're talking about them not just as hearing aids, but as aids to put the strongest foot forward through written submissions as well, or to be used in a mediation or other ways that we can do it, rather than something that's going to be prepared at the start but then held on to and used kind of much later on in the process.
Right. Speaking of the process, do you have a sort of a clear idea yourself about what you think would really help to get the main issues across? Or do you tend to consult a visual presentation company and ask their advice only because of their experience of working on hundreds or thousands of cases? And so which way do you go, or is it sort of half and half?
Oh, of course. Well, I mean, I think every case is going to be different, but certainly in my experience, it's the latter. It's looking for input from consultants. Lawyers have many talents. We have to be legally creative. We have to be commercially creative. And I think there are probably lots of frustrated artists amongst the lawyer population, certainly lots of frustrated actors. But I'm not sure that we're necessarily famed for our artistry, our ability to kind of create visuals that are necessarily going to communicate a message. And I think that having consultants who are able to listen to what the issues are in a case and come up with some suggestions of how that might be illustrated, or how it might be animated, or how it might be put in a visual way that would be really, really engaging and compelling, I think is an absolute must. Often lawyers will have a basic idea of what it is that we're trying to communicate, but we're not necessarily also as tech savvy as other consultants might be. I think we're certainly trying to become more so, but I think having the benefit of consultants who have added and worked on visuals in hundreds or thousands of cases, as you say, and who have got lots of examples of visual aids that they've used successfully is really helpful to see. And I know that certainly, on work that we've done together, or other cases I've been on, seeing some of those anonymized examples of other types of visuals can be a really kind of thought-provoking process about thinking about how to get a certain point across.
Right. What is your process? How do you persuade your client on the advantage of using visuals to help tell your story, or to explain a complex fact? I would imagine it must at times be quite difficult to persuade them, because obviously it's going to cost. And do you ever consider it for settlement as well as for the hearing?
I think there's a few parts to that question. Starting off with how we help our clients to understand that a visual might be useful to them. Often our clients are technical professionals. Again, as I mentioned, a lot of the work I do is in construction, infrastructure, and energy, and those disputes can be very technical. And so the clients who are speaking to us, they know their industry inside and out. And we are lawyers and we know the law inside and out. And so each time we have a new case about a new thing, a new piece of infrastructure, whatever it might be, we need to learn about it through our clients. And one of the ways that I found really useful to explain to a client that a visual might be used is that if they're using visuals to explain to me, their lawyer, what the dispute is about, then I'm going to need to use those visuals, or at least some visuals, to help educate the tribunal as to what it's about. Because, our job as counsel is to make things as clear and as easy as possible for the tribunal to understand. And if the issues are complex, if they're factually complex, if they're technically complex, and sometimes even legally, then often a visual is the way to do that. I think we've all become very accustomed to seeing pictures, plans, programs, diagrams in written submissions. In the same way, we can use visuals in our oral submissions. And I think that, when we are putting together a case, when we're putting together a case theory, even before we submit a first request for arbitration or statement of claim, if there are any visuals that I've needed to look at to understand myself what the case is about, then more likely than not, the tribunal is going to want or indeed need to see some visuals as well. And I think once a client understands that, then they understand the kind of the value of having visuals. As to whether or not we use visuals or we advocate for the use of visuals in respect of settlements, I think in our minds, we are always thinking about what's best for our client in the dispute. Sometimes that's fighting everything tooth and nail to the end. Sometimes that is maneuvering a client into the best position to negotiate a settlement. So settlement's always on our mind. We're always thinking about, is this a dispute that's right for settlement? Is this the right time to have those types of conversations? And just in the same way that visuals can be really useful in helping a tribunal understand the main points and issues of a case, same is said that can be said for a mediator, or indeed the same can be said for the other side. Often when you find yourself in a situation when you're having a mediation or even commercial negotiations between senior representatives, C-suite level members of the disputing parties, sometimes things come down to just a misunderstanding of the other side's position. And if those points can be communicated clearly and compellingly through visuals, then that can be just as effective as going through to a full final hearing and using the visuals in that scenario.
Yeah, absolutely. You used an interactive timeline for one of your cases that related to part ownership with a government of a gold mine. And the timeline also incorporated the market values over time of various minerals and damages incurred. How did this timeline graphic, how did it bring value to your case?
Yes, I remember that case well. It was one of the more memorable ones of my career to date. Our case was that the conduct of the state, the respondent state, in its treatment of my client, a gold investor, followed and was driven by the increase in the market price of gold and other precious metals and minerals, more particularly that the state in question had kind of followed a campaign of creeping expropriation, and that those acts of expropriation mounted and intensified as the price of gold rose. So what we wanted to do was to show the tribunal that you could map the rise in the price of gold and other precious minerals and metals to the treatment that our client was suffering at the hands of the state. And so we were able to use the timeline that you described to highlight a series of key events along a timeline with text boxes and pop out extracts of documents and correspondence that were on the record. So evidence that was on the record, overlaid with gold price rising as these events multiplied and intensified. And it was a tool that we were able to use during the hearing to kind of move it along as we explained, but it was also something that the tribunal was left with, and that they could take away in their deliberations, and that they could, roll forward, roll backwards if they were interested in what was happening with a gold price at a particular time when a particular fact was, when they were thinking about that, they could, maneuver it themselves.
Yeah.
And I think that definitely our sense was that was far more impactful during the hearing than simply just narrating that story orally. Seeing it alongside the oral submissions that we were making, I think really had some impact. And I think also knowing that the tribunal, when they were in a room deliberating after the conclusion of the hearing, were able to use that as well, certainly left us with confidence that was a correlation between those two things that they were going to really understand. So that was certainly somewhere where I think that the use of that visual and an interactive visual gave our case a lot of impact.
Yeah, yes, I remember that case well. It was very interesting working with you on that case. As a international arbitration lawyer, can you recall any other interesting cases where you either worked on or even was against you, where the visuals proved beneficial or even critical in clarifying or explaining complex, detailed arguments?
I can think of lots of cases where the visuals have been used to explain complex, detailed arguments, but I think another one of the uses of visuals can be scene setting and setting a tone. And one of the uses of visuals that sticks with me most clearly was a big dispute that I did right at the start of my career. And it was a dispute between an agreement between a North African petrochemicals company and a Scandinavian oil and gas major. And the dispute related to the export of LNG, liquid natural gas. And we, in preparing the case, we found a really old archived local news story showing the signing of an agreement between the state-owned petrochemicals company and our clients. And the whole dispute revolved around whether or not an agreement had been reached, and whether that agreement was binding. And we unearthed this TV clip. And we had all sorts of legal arguments, contractual arguments, but we found this kind of grainy old TV clip, and we worked with with tech consultants to turn it into a video that we, at the very start of the arbitration, the hearing, we were claimants, so we started our openings first, and before we even said a word, we dimmed the lights, we set up the TV screen, and this is long enough ago that the hearing rooms didn't have all of the great big projector screens that we now have, and all of the IT, and everybody arranged their chairs as if we were sitting down in a movie theater. And I think almost short of passing around popcorn, we all sat down to watch this film with the lights off, and we played this clip, and before we'd even started our opening arguments, the tone was set for the whole case, and there was this real feeling of understanding of what we had all sat there and watched and witnessed, and then the case that we put to the tribunal, and I remember it was hugely effective, and that for me was kind of probably the first time I saw just how impactful visuals can be, as I say, not just in communicating technical, complex arguments, but also just really setting the scene and setting a tone for how a hearing is going to unfold.
Have you encountered any cultural differences when acting in different countries or regions? How does it, or does it affect your strategy and visual presentation, depending on where the hearing is being held?
So culture, it has a huge bearing in international arbitration on how you make your arguments, your style of advocacy, how those arguments will be received by the tribunal, by opposing counsel. I think that for me is one of the amazing things about international arbitration, is just how much culture plays a part in what it is we're trying to do. That said, when it comes to strategy and visual presentation, one of the things that's common to arbitration, wherever it's done, in whichever jurisdiction, whichever part of the world, is that it's done by human beings. Our tribunals are composed of people, and people respond to visual imagery. So while there are countless ways that culture has an impact on arbitration and how we arbitrate, one of the things that in my experience has remained true is that wherever you are in the world and whoever it is that you are presenting to, everybody is able to look at an image and engage with it and respond to it in some way and be affected by it in a way that's possibly more compelling than simply oral argument. I guess one of the particularities of arbitration as well is that sometimes we'll have a tribunal in the UK that might be composed of KCs, King's Counsel barristers. It might be composed of former High Court judges. There might be a sense that certain types of tribunals respond better to more traditional advocacy, more traditional oral advocacy. But I think in reality, there's not a tribunal who hasn't been presented with a visual of some kind and found it useful to their understanding of the dispute. So, while I think, as I say, there are definitely cultural differences to how you arbitrate and how you present your advocacy, depending on where you are in the world, I think that visuals always have a place. Sometimes they might be less dramatic, less showy. Some tribunals might not be as comfortable with with a lot of showmanship. But I think if it's done well and properly and it's used in a focused manner, I think it's always going to be really useful.
Apart from different locations, do you have to reconsider what you're going to show depending on your audience? For instance, a judge or the arbitrators, barristers, do you have to take that into account as well?
I think you do. I think that you always have to read your tribunal, and you have to do that. You have to think about that in advance, and then you have to be able to do it on the hoof as well. You need to be aware and perceptive of how your arguments in your advocacy or landing on your tribunal. If you plow on ahead, irrespective of whether they're clearly not responding well to a certain style or a certain line of argumentation, or if they're all half asleep after lunch, then you're not doing your job properly. I think one of the kind of the facts or one of the truths about all tribunals, though, is that they don't want to be droned on and on at. By the time you get to a hearing, a tribunal has read probably hundreds, if not thousands, of pages of written submissions. They've got a good sense of what it is that they're here to hear. They don't just want a retelling of what they've already read. They want something fresh. They want, an engaging summary. They want what it is you're telling them to be presented in a new and engaging way. The UK has specialist technology and construction courts, and so often the judges who will be hearing those types of disputes will be very well versed in some of the certainly the legal issues and often some of the technical issues that you might be presenting. Similarly, there's a very well established construction bar in the UK, composed of barristers who are construction experts. And you can have a task kind of convincing them that you might want to present something in a different way. That said, I think that all tribunal members should be open to however party wishes to put its case in a hearing, and to the extent that a tribunal or a court is satisfied of the provenance of the data that's gone into a visual, and also that the other side's had or has had the same opportunity to interrogate that data and to kind of cross-examine on those visuals. I've never seen them refused. I've always seen them well received by tribunals and by courts.
I remember actually, Clea, quite a few years ago, I did a presentation with a whole lot of judges at the Rolls building, and I mean they were very keen about the visuals. There were two things that their interest. One, they were very interested in timelines because that helped them sort of be able to sort of look at, the process or when it happened. The other thing that they were interested in was where there was a complex issue, and they accepted that although they were experts in construction or whatever, they could not know everything, so sometimes it was really helpful for them to be able to see, how something was made or how it broke or why it broke, or, because it wasn't built properly or whatever the case may be. And the interest there was having a visual plus reading allowed them to understand something much more quickly and therefore save them time. And that is what was of real interest. There was one particular judge there, and we had sent him a little 3D model, animated model of a blowout preventer, which you have sitting on the seabed underneath an oil platform. And we did close-ups of various parts of it that related to the case. And he, he was there, so I was able to ask him, and we put it on a little memory stick and he took it home, and I'm sure his children played with it as well. I don't know, because it was interactive and you could click on certain parts of the device and it would, bring up close-ups or photographs or a little animation. But he said it really helped him understand exactly what had happened.
I can well imagine that that's the case. I mean, I think visuals like that, and sometimes even the 3D models that I know that can be prepared for, elements of a claim where it's about a faulty manufacturing component, whatever it might be. those can just really bring it home, really focus the
Yeah.
attention, focus the mind, and you know, it makes it turns it from just words on the page, or you know, words spoken by an advocate in a hearing, to something that really comes alive. And as you say, those timelines, I mean, there's thousands and thousands of pages of, you know, facts that a tribunal has to read through, but if there's a timeline that brings it all to life for them,
Yes.
I think there's so many examples where, you know, where we've seen that be used effectively. And you know, I can think of cases as well. I mean, again, you know, the construction sector probably is one that lends itself really well to this type of product. But you know, where you have a case about a delay, if you have your as built versus your as planned, you know, models, and you can see it being constructed on the screen
Yeah.
side by side. Or if something's a dispute about whether or not there was a change or a variation, and you can see that change or that variation visually manifest itself in those side by side comparisons. I mean, I think there's really nothing. There's nothing like that, you know, in terms of advocacy. I think that's really very helpful.
Yeah, absolutely. In today's world, your audience may well take part via Zoom. We've certainly seen an increase in use of our services for virtual hearings. Post-pandemic, how has the ratio of in-person to online hearings changed for you?
Radically. I think procedural hearings are nearly all virtual now, and to my mind, rightly so. I think that these are hearings that if we look back on how we did them pre-pandemic, we should have been doing these virtually or remotely in any event. And I think that that's a really good and welcome development in my mind. Those procedural hearings, in my experience, don't tend to be the ones where visuals really come into their own. The procedural hearings are often just that. They are procedural. There's a you know, a fairly formulaic list of issues that tends to be considered and discussed, and I think that those can absolutely be done virtually. We still very much see a preference for in-person merits hearings, and I think that the reality, both for tribunals, for parties, for advocates, for witnesses, for all of the actors involved, is that there's nothing quite like being in the room with your opponents, being able to look a witness or an expert in the eyes when you're cross-examining them, getting a feel for the tribunal and how they're responding in person. And I think there's still a lot of value to that. That said, I don't think I've had an in-person hearing since the pandemic that also hasn't had some element of hybrid to it, meaning that, you know, you still have the ability to access that in-person hearing remotely. So you might have members of your legal team who are back at base camp, or you might have members of the client's team, but rather than having to bring 10 people halfway across the world to attend a hearing, if they haven't got an active participation role in that hearing, they might, you know, stay wherever they are at their home base, but attend remotely. And I think that there's a huge advantage to that, both because of the environmental benefit, which I think is a very important one. I think we need to recognize that international arbitration has big carbon footprint, and I think we should be doing what we can to minimize that where it's possible. But also, I think it allows for the democratization of arbitration. And what I mean by that is that as a junior lawyer, it was a privilege to work on a case and then to be able to attend the hearing and to see your partners, your senior advocates on their feet, to see the procedure of a hearing kind of unfold and to learn that way. But you didn't always get to do that because either the hearing was somewhere else, or you know, the budget didn't permit it, or it wasn't justifiable. And I think now, with the benefit of IT and the kind of the prevalence of hybrid hearings, all of the remote all of the in-person hearings I've done over the past 3-4 years have all had attendees from our office, from the client, people who are there to also add value to the process, but also there to learn. And I think that's a great advantage. And I think that the more we can, bring IT and use it effectively in these hearings, I think the better.
Yes, yeah, I quite agree. Are you seeing any other emerging trends or advances in technology within the field of international arbitration? Are there any new?
Well, definitely. I don't know if it's new, but it's certainly the norm now, and it wasn't when I started, which is the use of e-bundles, electronic bundles, and lots of platforms and service providers who will host an electronic hearing bundle or case bundle on their platforms, which obviously obviates the need for printing dozens and dozens of hard copy bundles for every member of the team, plus the tribunal, plus the transcriber, and one for luck. So that I think is a fantastic development. And I think that that was obviously around pre-pandemic. There's a cost to it, which sometimes meant that it wasn't always used. And there was sometimes, I think, a reticence by tribunal members of a certain vintage to use electronic bundles. I think nowadays it is absolutely the accepted norm, and we are seeing some really savvy tribunals who are not just comfortable with it, but are actively asking for it, and they don't want, box loads of documents delivered to their chambers or to their home offices or to wherever it may be. People don't have an appetite for that anymore, and you can understand why. It was cumbersome and it wasn't efficient. So that's certainly a development, and I see that increasing and being used, almost all the time. I think that with the increased use of AI, I think that in not necessarily in the hearing end, but in the preparation of a case, we're going to see a lot more streamlining and efficiency in particular aspects of arbitration when it comes to things like document production, disclosure, and I think that's a very welcome development, and I expect we can see more of that. In terms of other tech that is more visual in nature, one of the things I'm starting to see more and more in the cases that I'm working on is virtual reality site visits. So where you are unable to attend a site either because it's locked down or because it's difficult logistically to get there, or difficult logistically to take a whole host of people there. These drone site visits, which can zone in on particular aspects of a site, or hover over a particular place, or can give you a virtual reality walkthrough. I think those are really useful and really entertaining, actually, and I think that they when used properly can be really effective in cases as well. So I suspect we'll see more of that. I don't think we're yet at a stage where we'll have hologram advocates and tribunal members, but given that ABBA does it, I'm sure it's maybe not too far off for us as well.
Talking of the future, how do you share your own experiences and knowledge to younger lawyers? What advice do you offer them about how to use it, or when not to, or when the best times to do it, and all the experience that you have?
Sure. Well, I think a lot of our learning comes from war stories that are passed down from more senior lawyers, and I think that there's diminishing value to the war stories of hearings with paper bundles that we used to tell our trainees about. Back in our day, we had to hand paginate things, and we had all of that's a bit archaic now. And so the best way I find to kind of impart arbitration strategy and the importance of using visuals is to do that in practice, and to bring junior lawyers along on the journey. We can share our experiences with junior lawyers about what's worked for us in the past, but ultimately I find that junior lawyers today are far more fluent with technology, and I find myself learning from them probably just as much about the tech as they might from me about the strategy. But I think that it all comes back to a strong, a clear, and a compelling story, and being able to tell a story. So I think that's the important thing to impart to junior lawyers, is that we are the storytellers. We need to get our client's story across, and we need to narrate that in a really compelling way. And there's various tools at our disposal to do that. We can do that orally, we can do that in writing, but we also have this additional tool of technology. And if our case theory is solid, there will inevitably be a visual angle to helping us to get that story told.
Yeah. Clea, thank you very much. You've been wonderful, telling us about your experiences and the future of arbitration. And thank you again very much indeed.
It's been a pleasure. Thank you, Cindy.
Okay, thank you.
Thank you to Clea and Cindy for speaking with us today, and a special thanks to our listeners. Please join us next time and subscribe to the IMS Insights podcast. IMS has delivered strategic litigation consulting and expert witness services to leading global law firms and Fortune 500 companies for more than 30 years in more than 40,000 cases. IMS consultants become an extension of your legal team, from pre-suit investigation services to discovery and then on to arbitration and trial. Learn more at expertservices.com.